My name is Jim Condos. With me is Eric Covey, my Chief of Staff, and Jenny Prosser, who's our General Counsel at the office. And Jenny also handles a lot of the municipal, we kind of call her the municipal director. She handles a lot of the municipal questions, kind of flow through her desk. We don't give legal opinions, but we do tell people what the law says, and but it's not an official opinion, although many towns would like us to do that, but we just don't do that. So we like to just explain what the law says, and two of the most important laws that we have are right here in front of us. It's the open meeting law and the public records law. I will say just a little background for me. I served 18 years on the city council in South Burlington. The last 8 of those years I was the chair. I served 8 years in the state senate. I chaired education and government operations. Government operations is the committee that actually oversees the Secretary of State's office, so that's where I have my background. And then I also chaired the Legislative Joint IT Committee, which means, I guess it's supposed to mean that I'm a geek, but I don't really know that much about computers except how to turn them on, and I hope someone else can make it work. So in any case, this came about in 2011. We first started to do it, and we realized that there was really a lack of understanding of the open meeting and the access to public records laws. Plus, we were getting changes coming from the legislature, and that was important that we make sure that people understood what those changes did and what they do going forward. We have improved the law since 2011, and we'll go through. This is an updated version, so Jenny updated it actually about a month ago. So just to make sure we had a fresh copy. So we'll get started. Why are we here? We're here because of democracy, accountability, and openness. The public has a right to know. Open meeting and public records laws protect our direct access and actually our access to those decisions that affect us. Understanding these laws makes us better citizens, either side of the table, whether you're a member of a board or whether you're a member of the public. So, who's the boss? The ultimate boss is the public. The Vermont Constitution says in Chapter 1, Article 6, that all power being originally inherent in and consequently derived from the people, therefore all officers of government, whether legislative or executive, are their trustees and servants, and at all times, in a legal way, accountable to them. Pretty simple statement. It's right up front in the Constitution. And then you go to this is the open meeting law, 1 VSA 311, and this is the Declaration of Public Policy. It also refers back directly to that constitutional line, but it says that the public commissions, boards, councils, and other public agencies exist to aid in the conduct of the people's business and are accountable to them. And then on 1 VSA 315, which is the statement of policy for the access to public records, it says that you have access to free and open examination of records, and this is an important sentence here, officers of government are trustees and servants of the people, and it is in the public interest to enable any person to review and criticize those decisions, even though such examination may be inconvenient or embarrassing. So there are Supreme Court cases that actually say embarrassment is not a reason to deny something. So we're going to talk about open meetings first. The first half of this presentation is about open meetings. The second half is about access to public records. The presentation itself will probably take about an hour, a little over an hour. And then if anybody has questions, just ask while we're going through it. Don't wait till the end. I don't want you to lose your thought. And we'll just try to answer your questions as we go. So who must comply to the open meeting law? Public bodies of the state and its municipalities. So it's the state and municipal boards, councils, and commissions, and any committees or subcommittees of these bodies. What's not included in that are individual officials themselves, councils established by the governor specifically to aid in providing advice to the governor, the judicial branch, the public service board, and generally nonprofits. And we say generally because nonprofits, even though they might get 100% of their funding from the state, they may not be, there's no requirement for them to follow the open meeting law unless their charter says so, or the funding stream has a string attached to it that says they must do it. Now, for, an example of that was a couple of years ago, Vermont Public Television got into a little brouhaha over some of their meetings being closed, and it was the Centers for Public Broadcasting is their main funding source, and in the tied to that funding coming from them was a requirement that they follow the open meeting law. So as a result, they had to. When does the open meeting law apply? So there's two pieces to this. One is a quorum, and a quorum is defined as a majority of the entire public body. So if you have a 5-member board, 5-member select board, 3 members is a quorum. If it's a 7-member board, 4 members are a quorum. And a meeting a gathering of the quorum, of the public body, if they're going to discuss business that they have authority to discuss. So, and I think there's another, yes. But this piece in the middle here is about joint authority. This is really about the, if you have well, for instance, in zoning board days, I used to serve on a zoning board, and in zoning board days, we had a 7-member board. We had 4 members was the quorum, but 4 members, you had to have 4 affirmative votes in order to take an action. So you couldn't take an action with 3. So if only 4 people showed up, 3 didn't qualify. You had to have 4. And that's what that's referring to. So when also does the open meeting law apply? It applies, well, it can occur, the meeting can occur regardless of where the meeting is. So we often will get questions about, well, they said that they were going into a work session. There's no such thing in the statutes as a work session. If you have a quorum, you're meeting and you're talking about the agency or board business, you're in the meeting, period. A meeting can also come together over a span of time. This is one that we think is going to come up in the future, probably in some kind of a court case at some point, specifically around emails. And if you send out an email blast to everybody on the board, let's say this town manager sends an email to everybody on the town board, and the strings start going back and forth where they're talking to each other by email, the public has no knowledge of it. And technically that could fall into the span of a meeting. But we haven't had a court case yet, although we think one's moving along and may end up there. But we're waiting for a court to actually decide that question, unless the legislature makes it clear.
Can I ask you a question about that?
Sure.
Does this mean that, and my question may have a few parts, because I do a lot of municipal reporting, so this is something that's really important for me. Does this mean that it's not suggested that this kind of business be conducted over email? Or does it mean, and maybe both are true, that anybody in the audience can have access to those emails if we want to see them?
Yes and yes.
Okay.
So here's the situation. If the town manager or someone representing the town manager sends out an email to 5 members of the select board, the 5 members, with some documents attached, maybe, here's the agenda, we're going to, or that's okay to send that out, to blast that out to the board. If the board starts discussing it though, then that's not okay. But, and what we always recommend to people is, if you're going to do that, when you hit reply, make sure you hit reply, not reply all. The minute you hit reply all, you've now opened it up to everybody on the board.
So then you're hitting a quorum.
You're hitting a quorum.
Okay.
And the public has no way
That's
of,
the crux.
Yes, and there's no way for the public to even know that that's going on. The public or the press, and the public and the press are one and the same. Yes, ma'am.
Okay, let's say you're calling all the members through email to do a meeting, and then you want to ask everybody what they'd like to put on the agenda.
I'll get to that in a second.
Okay.
That's a great question, though. And we actually, it was kind of gray for a while, but this past year, the legislature directly spoke to that. Well, actually, it's right here. So a meeting does not include communications to schedule a meeting or organize an agenda or distribute materials to discuss at a meeting. It does not include clerical work, staff work assignments, routine day-to-day administrative matters, site inspections, or quasi-judicial deliberations. Quasi-judicial deliberations would be like a development review board when it's acting on a development review. That would be they're acting like a judge.
So if I want to distribute information to all the committee members, I can do it without any problems.
Correct.
But if they email me back because they want clarity, then does that?
Well, as long as it's about these things, if you're trying to schedule a meeting or organize an agenda, and if you send out the email and you say, what would you like to have on the agenda this month? And people can respond back for that. That's okay. It's if you start discussing those issues where it becomes a problem. And that's where it's kind of crosses the line. So you need to be careful about that.
Okay.
And I'm not the police, I'm not coming after you.
Jim, what about, I've heard a couple of my select boards kind of throw jokes around about this, about, there's going to be a town picnic, say, and it's a 5-member select board, and 4 or 5 of them are probably going to be there because they want to represent. They joke about, do we have to warn this? So what if it's, a civic engagement where town business might get discussed?
Well, the question is, you say might get discussed. Yeah. And I guess I'll ask Jenny, but I think as long as they're clear that they're not going to discuss business, they're fine to be there together. And we often hear, there's 3-member select boards in the state, and the 3 members are at the coffee house. And as long as if they're talking about the Red Sox or the Patriots or something, that's okay. But if they start talking about plowing roads and things like that, the budget, that's not okay.
Or 2 members, right? In that case.
In that case, yeah. Well,
that's a quorum.
A quorum would be 2 for a 3-member board. So, did you want to add anything to that?
No, I think that's exactly right.
So, it really comes down to it. There's the chance that they might talk, but as long as they're clear that they can't.
And I guess I will add that you can cut off a conversation when you feel that it's going that way. That's when you stop it.
So, advanced public notice. What public notice is needed? So there are 3 kinds of meetings. We have regular meetings, special meetings, and emergency meetings. For regular meetings, that's usually it's a resolution at the beginning of your organizational meeting, right after town meeting day. You have usually a resolution that you pass that says, we're going to meet the 1st and 3rd Mondays at 7 p.m. at the town hall. Three criteria. 1st and 3rd Mondays, 7 p.m. at town hall. If any one of those 3 items changes, you meet at 6:30 or 7:30 instead of 7. Or if you meet at the town hall this time, but next time you meet at the school, or you meet, because it's a holiday on a Monday, you meet on Tuesday, then it falls into a special meeting. So as long as everything stays the same, you don't have to notice that you're going to have the meeting except for posting the agenda. The agenda has to be posted for a regular meeting at least 48 hours ahead of time. For a special meeting, 24 hours notice of the time, the place, and the purpose. You have to generally notify the newspaper or radio station that serves the area, and any person who specifically asked in writing. So if a member of the public or the press, either one, were to write a letter to the board, to the town manager, and say, I want to be notified of any special meetings, then you only have to write that letter once for the calendar year. So you could do it in January or you could do it in November. If you do it in December, it's good for the next calendar year too. But you only have to write the letter once, and you should be notified of any agendas and scheduled meetings. Emergency meetings, the easiest way for me to describe an emergency meeting is really about act of God. It shouldn't be about, oh, we forgot to sign papers on Monday, and therefore I'm going to call an emergency meeting on Friday so that we can get together and sign those papers. You can still do that by a special meeting. You only need 24 hours notice. An emergency meeting means you don't have to notice, you have to notice, but as soon as possible before. And I will tell you, just think about it, in August, September, October of 2011, there were emergency meetings happening all over the state. Hurricane Irene. So in some cases, they didn't have a city hall or a town hall anymore. So emergency meetings really should be very rarely used. We had a situation, one town up in Chittenden County this year had called an emergency meeting. It was in the paper. They called an emergency meeting to sign some paperwork that they forgot to do on Monday. But, we talked to them and told them that, hey, that's a special meeting. You still have to notice it 24 hours ahead. They said, well, it was an emergency. We had to get it done. It would be a special meeting and you have to notice it 24 hours ahead. Agendas. This was added 2 years ago?
2014.
3 years ago. So before there was really, agendas had to be available prior to the start of the meeting. Now there's a specific time limit. For a regular meeting, it's 48 hours. For a special meeting, it's 24 hours. If the town maintains a website or designates a website as their official website, then it must be posted on that website. And it also must be posted in or near the town clerk's office and 2 other designated public places. And we always tell people, make sure when you pick your 2 other public places that they're the same public places each time. You don't want it changing all the time because the public wouldn't know where it is that you're posting it. And anybody that is asked, it should be made available to anyone prior to the meeting on a specific request. Is there anything else? Yes. This pertains to the actual agenda. So the agenda should address all the topics that are going to be discussed at that meeting. So it should, and we see agendas that say budget, personnel, whatever, highway. You really need to make it a little bit more in tune to what you're going to be doing with it. What about the budget? What is it you're talking about? What about personnel? Is it a staff person? Is it a discipline hearing? Is it a evaluation? Just a little bit more information. Because remember, your minutes and your agendas are the history of your board. That's what people will see. In 5 years from now or 10 years from now, when someone goes back and looks, they want to be able to tell what was that meeting about. The other points that are being made here that the legislature added, to be clear, the first act of business on an agenda should be, is there any addition or deletions to the agenda? And you can also make some minor adjustments if you're going to, well, let's say you have a solid waste district. The county solid waste district is scheduled to present their budget to you at 8 o'clock on a Monday, and 5 minutes of 8 and they're still not in the room, but you know they're on their way. You can say, we'll take this later in the agenda. The part about additions or deletions is important because you want to make sure the public has to know what's going to happen. And we've seen cases where a select board would deliberately hold off putting something on their posted agenda because they knew it was going to be contentious, and they wanted it to get to a point where they could just bring it up in their meeting and discuss it without having the public all over them about it. So that's why this was made. And the other point I would make is if you add something to the agenda, typically when I was chair of the city council, the manager would say, I've got 3 items I want to add to the agenda, and I'd say, fine, hearing no objections, we'll add them to the agenda for information purposes only. Any action needed on those will be done at the next scheduled meeting when it can be properly warned. Minutes. We get tons of questions about minutes. What has to be on them? What is part of your minutes? We often will hear people say, well, I said this and they didn't write it down in the minutes. Minutes are not supposed to be verbatim. What they're supposed to do is give an indication of the business of the meeting, cover all the topics and motions. They should list the members of the board that were present. They should list the active participants who were there. And then they should list any motions, proposals, resolutions, dispositions, the vote results, and if individual votes, if there was a roll call vote. Other than that, it's not a whole lot of information. But it gives you enough that you would get a flavor for what that meeting was about. When are the minutes due? They're due no later than 5 calendar days after the meeting. And that, ladies and gentlemen, was there for the last 30 years. That hasn't changed, the 5-day rule. What did change in 2014 was we added, or the legislature added, that it has to be posted to the website within 5 days. Now, we had a lot of towns that were threatening to take their websites down because they didn't want to have to comply with the 5-day rule on their website posting. I didn't have a lot of sympathy for that because frankly, in the old days, yes, you might have, 10 years ago when it would take time for an upload onto your website. But today, it's point, click, and it's up. It's not that difficult. We actually asked VLCT to do some training on that.
Can I ask you a question?
Sure.
Just Ian Keel, PCTV. What is that phrase, dispositions? What does that mean?
The result of a resolution, the result of actions that were taken or a result of the discussion.
Okay. But it's different from vote results.
Yes, vote results is the actual vote, a motion and a result.
Okay.
5-0 in favor or 4-1 in favor. I think I get everything on that. And the other piece that was also available before, or was also part of the law before, was that they have to be made available for inspection and copying upon request within the 5 day, after the 5-day period. So that's always been in the law, as has the 5 days. The only thing that was added was adding it to the website. So when can a board meet in private? This is executive session. And this is probably one of the most difficult and most often asked questions that we get. What is it? An executive session is a closed portion of the meeting where the public is not allowed. When is it appropriate? Only if the business to be considered fits into one of the 14 statutory categories that are listed. Actually, some of them are grouped together, but there's 14 overall. And in order to go into executive session, you have to begin in an open session. So you have to have a properly warned public meeting first. We will see often where a town will say their normal meeting will start at 7 o'clock. But tonight they're going to have an executive session that's going to start at 6:30. First of all, that's not a regular meeting anymore because now they've moved the time start to open up their meeting. But if they open their meeting at 6:30 to go into executive session, that's okay, as long as they were in an open meeting that the public could have participated in, that the public knew about. They could have, and then had a motion in the open meeting to go into executive session. It's not okay to say we're going to go into executive session and go into executive session before the open meeting even opens. That's not okay. And is there a question on what you do?
Tim Wessel, our select board, Jan Anderson from Town Manager's Office.
We were just looking at each other because we go into open session to vote to go into executive session, and we usually manage that time either 45 minutes before, maybe an hour if it's very busy or something, or sometimes even 15 minutes. But we do it before the regular session where everybody knows that once the agenda is going to start. That's okay, right? Because
As long as you've warned it that way.
And we
Yeah,
warn
we
it.
do.
As long as you've warned it that way.
yeah, it's just that unfortunately when we know we have to talk about something in executive session, we wind back the clock so that everyone coming that wants
Yeah.
to be in public comment that we do.
We rarely did it before the meeting because we felt we didn't really know. You might not have all the information you need until you have the open
Right.
meeting, so.
Right.
But there are some occasions where you would.
I think we do it mainly because that way people don't show up on time and then have to wait for our executive session, which is frustrating.
Yeah, if you're gonna do that, where you have your executive session first, you should make sure you're starting your regular meeting on time. So,
Yeah, Jan keeps us to it. When that knock comes, we jump.
so, again, the last thing here is, executive session is really only for talk, no action, with the exception of one item, and that's real estate options. So you can not have a motion in executive session except to deal with real estate options. And we had, actually this was even before Jenny was with us, but we had one town that I got a call from the press, and this is how the story went. So the town's select board went into executive session. They came out of executive session and they had a motion for action. And I don't know that the motion for action was legal. And I said, well, what did the motion say? And she says, it said, we are taking a vote to affirm the decision we made in executive session. And I said, no, what did the minutes say? And she says, that's what the minutes said. And I said, can I call you back in 15 minutes? I need to call the town manager. But that same town also at one point had a minutes, in their minutes, it said, to affirm the decision we made by email. So, they don't do that anymore. So let's see. All right. So executive session, the permissible reasons. The first section talks about premature public knowledge would clearly place the public body or persons involved at a substantial disadvantage, and that's about contracts, labor relation agreements, arbitration or mediation, grievances other than tax grievances, and pending or probable civil litigation or prosecution where the public body is or may be a party. And the last one here is about confidential attorney-client privilege. So you might meet in executive session with your attorney.
What does that mean by grievances?
Typically, it's labor grievances. A city employee or municipal employee may have gotten a bad review and they file a grievance with the town manager first. Then after the town manager denies or approves, then it might get sent up to the city council or select board.
Thank you.
I have a question about that, and this came up in a story that I had been working on for about a month or so. There was an elected official in a town who stopped showing up for her job. And they were talking about that in executive session. And so the confusion I have is, when does that person stop being an employee? And how much do we have the right to know when that person's an elected official about discussions that the public might need to know about their behavior while in office?
You want to take a shot at this one?
Sure. So one of the reasons it is permissible for entering executive session is disciplinary dismissal action against a public officer or employee, or appointment, employment, evaluation of a public officer or employee. So what you're getting at there is this person, an elected official, a public officer? That is a complicated legal question. It has not been decided by the Vermont courts. So, I mean, I think it would be a public officer would be clear, somebody who the board itself has the power to appoint or evaluate, right? That would be fairly clear. That person would fall within a public officer. Whether that could be more expansive than that is anybody's guess. We'll see what the courts say if it goes there.
In this case, the select board didn't have the authority
Right.
to reprimand, hire, fire, because it wasn't appointed.
So I have heard of, well, and I think you're going to get a different answer from different attorneys on this one, because it's like the courts haven't, the statute isn't very clear. The courts haven't weighed in on it specifically. I have read opinions by attorneys that is an acceptable thing to do. I think it's arguable. I think, it's not clear in the law.
And do you know, are there any court cases pending, or is it anywhere in the legislature that anybody's working on this right now?
Not that I'm aware of in either case. Although there could very well be some lower court cases that I haven't heard of, but
Oh, okay.
not that I'm aware of.
And keep in mind, if the person is an elected official, elected by the people are the ones that can hire and fire that person by unelecting them at the next election date.
Or have a special election?
Unless,
Well,
unless they
that's,
really want-
you're talking about a recall?
Yeah.
Unless your charter has a recall provision, most Vermont town charters do not have a recall, and it's not in state statute.
And a lot of towns don't have charters.
Most towns don't. There's about 40 some odd towns that have charters.
It's tricky.
It can be,
As a
and that one we've wrestled with. Other permissible reasons include, as I said earlier, negotiating or securing a real estate purchase option, the appointment, employment, evaluation, discipline, or dismissal of a public officer or employee. This one pertains mainly to school boards, student academic records, suspension or discipline. This talks about the exempt public records under Public Records Act, clear and imminent peril to the public safety. And the last one, municipal or school security or emergency response, came about as a result of Sandy Hook. When we had a lot of requests, or people were requesting, what is it that towns were doing or schools were doing for security purposes, and that's when people realized, geez, if we tell people what it is we're actually doing, the bad guys are going to know too. So the legislature decided to make that an exemption to go into executive session. Do you have anything else you want to add on?
No, I don't think so.
When you say exempt public records, what are those?
We're going to talk about that in the second half of this. So you can also have meetings by electronic means, specifically a member participating remotely because maybe they're out of town on vacation, but it's an important meeting. You need their input or their vote. There are two things that need to happen. One is that when the meeting convenes, the person who is on the phone or on Skype or whatever must identify him or herself, and they must be able to be heard and to hear everything that's going on in the meeting. If a quorum or more is participating remotely, then an agenda must designate a specific physical location where the public can attend and participate, and one member or designee must be physically present. I think back to the days of Act 60 when the school funding law was put into place. There was a deadline for tax stabilization agreements had to be done by July 1st. We happened to have the airport, or at the time I was chair of the city council in South Burlington, and the airport, which is owned by the city of Burlington, we always entered into 10-year tax stabilization agreements with them. And we were getting down to the nitty-gritty. We were getting down to the deadline of July 1st. And it just happened that 3 out of the 5 of us were out of town on vacation. Uh-oh. It's in there somewhere. So we actually had 3 people on phone. We said that the town manager's office was the specific, this is before the law even occurred or happened. And we said the public meeting would be held, 3 members would be on a conference call, and we held it at the town manager's meeting, town manager's office. There was actually a member of the public that showed up and participated. I guess we were just ahead of ourselves at that time.
So we can have these like that, meetings by electronic means, like especially in the winter when the other members are out.
You could, but you have specific rules that have to be followed. You have specific rules. Any vote that's not unanimous must be taken by a roll call. So if you're going to have any dissenting votes, you need to call the roll so that everybody knows who voted which way. Public participation. This is the key to all of this on the open meeting law. Members of the public have a right to attend the meetings, obtain the agendas in advance, be notified directly of any upcoming special meetings. There must be disability accommodations if necessary, and they have a right to participate. The public has to be given a reasonable opportunity to express their opinions on matters being considered, subject to reasonable rules. So we used to have a $10 million operating budget when I was there. And we would have 2 people show up for the public hearing on that $10 million budget. And then one day, like a week later, we had a change. We were going to be debating a change to our leash law, specifically around the bike path. And so 2 people show up for a $10 million budget. 150 people show up for the leash law debate. 75 were for it, 75 were against it, and everybody wanted to give us their 2 cents. So I set reasonable rules. I said, okay, sign-up sheet in the back of the room. We'll go down the list according to the way the people signed up, and you have 2 minutes to speak. And please, when I say stop, stop, so that everybody else can get a chance. That's what reasonable rules are. I know that the city of Burlington has a 3 electric lights. They're colored. One's green, yellow, and red. And the whole sequence is 3 minutes. And I think it's 2.5 minutes of green, 30 seconds of yellow, and then it turns red. And when that red light comes on, they cut you off. A couple other groups have something similar to that. The public bodies have the right to limit to a reasonable set of rules. I went back to our city council with 3 of my colleagues. They were going to take away benefits from the recently retired city manager, retiree benefits, and we went back because they couldn't find anything in the minutes. So we went back to explain that we had taken that action. We didn't know why they weren't in the minutes, but we had taken that action. So the new chair said, is there anybody in the audience that would like to speak tonight? And 3 of us raised our hands, and she says, okay, I'll give you 30 seconds. And I went, 30 seconds? I can't say my name in 30 seconds. So we ended up speaking a little longer. So why comply with open meeting laws? Because meetings held without respecting the details of the law may be illegal, and the courts can regard any actions that were taken in any of those illegal meetings as voidable. So the court could overturn. You could make a decision, and if you didn't follow the right process, the court could overturn it and say to you, go back and do it right.
I have a question. So is that really the only way? Is that the only teeth in this? If a select board.
No, we'll get, there's some more behind this.
Okay, all right.
That's just kind of a general rule.
Okay.
Illegal meetings do offend our notions of openness, accountability, and our democracy. In Vermont, the people do rule, sometimes directly, sometimes through their elected or appointed representatives, but always with the benefit of public scrutiny. So, here's where some of the enforcement comes in. The following persons can be charged with misdemeanors and fined if a member of the public body knowingly and intentionally violates the open meeting law. So if someone deliberately, willfully violated the law, knowing that they were wrong, they could be charged with a misdemeanor and fined.
You have to prove that they know it and that they intended to.
Well, it's a high bar, and it really is, but it's there. And then a person who knowingly and intentionally violates the open meeting law on behalf of another member of the public body, or a person who knowingly and intentionally participates in the wrongful exclusion of a person from a meeting. So we've had occasions where someone might be very belligerent at a meeting, and you can certainly ask people to leave, but you can't just ban them from the room and say you can't come back. They have, remember that piece about embarrassment is not a, or inconvenience is not a reason to withhold? That's partly where that comes from. The Attorney General or any aggrieved individual can also bring suit in court asking for an injunctive relief, in other words, to stop a specified act or behavior by the board. They can look for a declaratory judgment, in other words, make a binding determination of the rights, and they can also, the court can order the public body to pay the attorney's fees for the person that filed if they win substantially. Enforcement. So here's how it starts. If this is, I think, going to what you were going to say. If someone thinks that there was a specific violation, you can file a written notice to the public body by the person who was aggrieved, or to the Attorney General, alleging that a specific violation occurred and requesting a cure. The public body must respond within 10 calendar days, acknowledging the violation and stating the intent to cure, or stating that no violation occurred. So they can say, yes, we believe that we did do this wrong, or no, we don't believe it. The public body's cure, if it acknowledges a violation, must be within 14 calendar days, and that's saying that the public body must meet and resolve the situation in a public meeting, ratifying or declaring as void the action taken at the improper meeting, and then adopting specific measures to prevent future violations. The aggrieved individual's recourse, if unsatisfied, is they still have up to 1 year to file a lawsuit. So there is a time limit, but it's pretty lengthy on that one. So that's the end of the open meeting law section. So we'll take any further questions you might have on that before we get into the public records, and then we'll get into the public records.
And Ian Keel from BCTV, just with a question. Have there been recent cases going to the court based on this? People?
I don't believe so.
I mean, there's probably a bunch in the lower courts. But the Supreme Court hasn't heard of one in the past, not super recently.
Can you clarify lower court?
The district, or the
Superior Court.
The superior courts. So the counties.
And you know what also will happen is someone might file with the Superior Court, and at that point, the public body will say, okay, the threat's been made, we'll cure this problem. And sometimes it goes away without even going anywhere. So it gets fixed.
And then just another question, again, Ian Keel from BCTV. This is a position I'm in a lot, where I'm videotaping public meetings. And is there any specific issues that you folks are familiar with in the terms of public access and its relation with open meetings?
Actually, we used to have a slide on that here. We took it out to make this a little bit shorter, but specifically, there is nothing that would prevent, as long as you're not being obtrusive or anybody else isn't. In other words, if the select board was meeting up here and someone was sitting out there and they just turned on their recorder and put it up here, the select board can't shut that thing off. The select board can't tell you to shut your camera off. We actually had a case west of here where a select board chair and a member of the public, it was about 2 or 3 years ago, got into an argument, and the select board chair realized the camera was running and ordered, it was a young guy who it was his first time, he ordered the camera to turn it off because he was embarrassed that the public might see this spectacle going on in front of him. They were told in pretty clear terms the next day that that's not acceptable. That camera had every right to be on, and that person had every right to be there and taping it. As long as you're not obstructing or, do you have this specific language?
I'll say that the law itself doesn't speak to it. So I think what Jim is referring to is what we think is best practices and what we think a court would do if it were challenged. We say that folks have a right, individuals and the press would have a right to record meetings if they so wish. But the law itself is silent.
Thank you.
I had a quick,
Sure.
and this is a little esoteric. This perspective is certainly about open meeting law and sunshine and that kind of idea, and that's terrific, and I'm a big supporter. To push back against that, though, to conduct the business of the town is the charge of a select board. What's your sort of stance on when an agenda from a member of the public, for instance, starts to intrude on the ability of that board to do the business of the town? In other words, if somebody basically kind of insists on monopolizing, it's my understanding that a board does have the right to silence in some way, cut off.
I don't do that often.
No. We're talking hypotheticals here. You see what I'm saying, though?
Yes.
It is important for the select board to conduct their business, obviously, because we all have limited time in order to do so. So where is that gray area, and what's your comment on that gray area of?
Well, let me tell you what I think, and then Jenny can tell you what's in the law, but my personal feeling is, if you go back to this comes right out of the law, a reasonable opportunity to express opinions on matters being considered subject to reasonable rules. If someone is taking up time, you can put a limit on the amount of time that they take. I don't know if you can limit them how many times they speak on something, but you probably could say, look, no more than 2 times. We'll accept anybody that wants to speak, but you can speak for 2 minutes or 3 minutes, but no more than 2 times on an individual topic. I think that would be a reasonable rule. On the other hand, I also want to just strike what you said about we have business to get done and that's what we're charged with. Yes, you do, but again, you still have to deal with this public participation piece. And I always say to people, the fact that you're going to be inconvenienced because maybe 30 people show up and want to speak, and it delays the work that you want to do. There was nothing when you got elected, nothing in the statute that says select board meetings go from 7 to 9:30. So if the topics that you're dealing with have a lot of activity around them, and you don't get out till midnight, I guess my opinion would be that so be it. That's what it is. Now let Jenny look at the law.
Oh, also to say that there's a bit more to that phrase in the statute, that the public shall be given a reasonable opportunity to express its opinion on matters considered by the public body during the meeting as long as order is maintained. So you have that piece also. There's reasonable rules, which I would say applied fairly I would add that, try to apply that as fairly as possible across the board to folks. But also as long as order is maintained. So if somebody is being disruptive and keeping the board from getting its business done, you know, what's reasonable in that circumstance? You know, right.
Thank you.
And is it also reasonable then if a member of the public has talked their 2 minutes or however many minutes, then goes off topic, it's reasonable to bring it back
Yes.
onto the topic that was warned?
I would say that is, and we often would do that when someone would start to segue into something else, and we'd say, hey, wait a minute, we're talking about this item on the agenda,
On matters considered.
you know, so keep it to that. Betty?
So, the state has like about 11 or 12 regional development corporations.
Something like that.
Where do they fit in this? Are they a government thing? Are they private or?
I think they're considered nonprofits.
I would have to look at.
We'd have to look that
the
up.
labeling statute if there was one.
I've never had that question come up.
Now,
Kind of like to know.
now that we're asking, I'm setting up a tenant association. So if I come in and not use just the participant area, but actually try to put something on the agenda, how does how long does it take to get put on an agenda? Because
I
that-
can't
But
answer
that's a
that.
citizens committee that she's referring to and not a municipal
Correct.
committee.
Is it a sanctioned committee?
No.
Okay. So a sanctioned committee would fall under the rules of open meeting law. A non-sanctioned committee, in other words, a separate committee that maybe a group of citizens form
Right,
to advise or whatever,
not to advise, but
okay,
to, well,
to spur
we
change.
went through it already in a way. Is that certain things weren't being followed here in town by landlords. And part of it had to do with the policy of the Brattleboro Town Select Board Committee saying they were following the state guidelines or what the state had put out for landlord tenants. I had come in and said some things, and I did take up a lot of time, I admit that. But it was happening to more than me, and then I had some lawyers involved that said that this area had the highest percentage of evictions for the state of Vermont. So he said, and the state people kept telling me, go back to my town, go back to my town, the state health and safety and all that. Go back to my town, talk to the select board. So now we've set up an association, and we're gonna come in force. Or multitudes, not force. Okay. And so, how do we, if we want to be put on the agenda, or just take that participation time, because it will take more than 2 or 3 minutes?
Well, technically, by Robert's rules, the chair of the select board has the power to set the agenda. And sometimes he may designate that to the town manager to set it up for them, but they'll probably tell them what to put on it. So there's no time limit. I can't tell you that they would give you, you know, that we'll put it on in the next meeting. Their next meeting might already be scheduled. I mean, they might already have an agenda. So I hesitate to say that there's any time limit. I think it's just a matter of being persistent and asking and getting an okay from the town select board or the town manager that they'll put it on the agenda.
Yeah, they know me.
We'll be open to that.
We all want to get along.
Yeah.
Okay, so the next section is public records. This will go fairly quickly, I think, depending on questions. What is a public record? So this is the definition. We broke it up into 3 sections. Any written or recorded information, regardless of physical form or characteristics, which is produced or acquired in the course of public agency business. So there's three components to this that make up a public record. The other thing is public records are not limited to just paper. All government records are considered public, but some public records are exempt from disclosure, and there's a lot of exemptions. So who must comply with this? Public agencies of the state and its municipalities. That includes state municipal agencies, boards, departments, commissions, committees, branches, instrumentalities, and authorities. Not included is generally, again, just like before, nonprofits, unless there's something specific in their charter or in their funding stream that's attached. Who may ask to inspect or copy a public record? Anybody. And this was a Supreme Court case, Schlansky versus the City of Burlington and the Burlington PD in 2010. And this is a direct quote: "The identity and motive of the requester cannot be considered when weighing access to public documents." So it really doesn't matter who the person is or what they want to do with it. If something is a public record, they're entitled to it.
So you don't have to answer if they say, why do you want it?
That's correct.
Thank you.
How do you make a request? First you may inspect the state records. If you want to just inspect, you can inspect the state records on weekdays from 9 to 12 or 1 to 4. Municipal records are during customary business hours. And this is because we have a lot of small towns in the state of Vermont that might be open only one day a week. Some tips for people who are requesting information. There is no in-writing requirement, so there's nothing that says it must be in writing, but it's really a good idea because you're more apt to get action on it. You're more apt, you have a paper trail that says on this date you asked for this document, because there are some deadlines involved, and we'll get into those. Also, you get to list or specifically describe the records you want to see, and you must be clear, do you want to just inspect records, or do you want copies of those records? If you want to inspect, it's free. If you want copies of those records, could be a cost to it. Again, date your request and include your contact information. And that's in case they have questions, they want to be able to contact you to maybe narrow the scope, or to say that they don't have any records, but it's going to be a little while before they can actually formally get that to you.
Could I ask a quick question?
Sure.
This is Ian Keel, BCTV. You said there's a difference between inspect and copy. The issue of many people have a powerful phone in their pocket, a powerful camera in their pocket. Could a person request to inspect something and take photographs of those documents that they've requested to inspect?
We get that one too. We're going to talk about actually similar point, but the simple answer is that it's supposed to be any charges or fees for public records, copies of public records, is supposed to be at actual cost. And our argument has always been, if I'm using my cell phone to take pictures of documents, there's no cost to the town. The cost to the town might be in finding those documents, but there's no cost to the town for my taking those pictures. The caveat to that is some towns have adopted ordinances of their own. I'm speaking to the state ordinance, which everybody has to follow unless they have their own, which the select board would have passed. So if the select board has its own fee schedule, then the fee schedule from that select board would follow, and they might have something in there about taking pictures by phone. I don't know. It's a relatively new phenomenon, but it's happening more and more.
I'm just curious, if there have been cases where people have considered copying fees unreasonable and challenged them.
Oh, yeah. Not for that specific reason, but yeah, I mean, Vermont Digger filed a public records request to the Attorney General's office last spring and was given a bill of $200,000 if they wanted it. So, but if you're going to, if the agency is of government that is going to charge a fee, They have to tell you up front before they go do the work for it.
Has that specific example entered the court system?
I did it.
I don't know if that's a piece of one of these. There's a lot of cases
There's a
brewing
lot
right now.
This
that-
had to do with EB5.
I mean, I'll say that the open meeting law has a strong distinction between an inspection, which is free, and a copy, which can be you can be charged for under certain
I mean,
circumstances.
public records.
Excuse me, the public records law. However, the law itself, the language of the law, does not jive beautifully with technological advances. It hasn't been updated. So you end up with these situations. Is it an inspection or is it a copy? Is it free or can I charge? And I think you ask a different attorney, you get a different answer. There are some of these cases are being litigated. I know that there are towns and also some state offices that will charge you for taking your cell phone out and snapping a photo of a record. I'd say we don't interpret the law to allow a charge for that. We think that is an inspection. It remains an inspection. It doesn't change. Other attorneys will make a different argument, and we won't know what the answer is really until the courts make a clarification, or until the legislature takes it up, which they might this session.
This is one that's coming up more frequently.
Does that include the police records and motor vehicle and all that?
I hesitate on the motor vehicle, but police records, actually, they do have to comply. We're going to talk a little bit about that in a minute, not specifically to that, but
Go ahead.
well, that's good. You're thinking, but police records actually, and like getting a copy of the public record of the police report, getting a video of a copy of the video. There are specific statutes for that as well. So, for instance, I think a CD, whereas in the Secretary of State's fee schedule, if you ask for some documents and I gave it to you on a CD, I can charge you 85 cents for the CD. All right. In the police report, or if you get the police video, they can charge you, I think, $40 for that. But that's embedded in the statute.
So it's broadly saying the police departments are public agencies, so their records may be defined as public documents. And the question really, what it comes down to is there an exemption that applies? And there are a bunch of different exemptions that apply that are very complicated to certain kinds of criminal records, and it applied differently depending on what kind of police organization you are.
Well, no, if you, I put in a complaint. One of my neighbors was out to lunch, and I put in a complaint, please come take care of this mad person. And they wanted to charge me $5 for a copy of that.
So that may be a local ordinance. I can't speak to that. I wouldn't know what it was. I mean, but there are embedded in the statutes for certain police records. There's a fee actually embedded. It's actually in the statute.
And I would add that you can always ask where someone is getting the dollar figure from. They should be able to point to a statute that gives them authority to charge the fee that they're charging.
Or an ordinance that the town may have passed. So if an public agency gets a request for documents, they must promptly produce the record for inspection. The only exceptions would be if that record was already in active use. For instance, it was part of a computer program that the town manager or the town clerk is actually using on a regular basis, or it's exempt under the statute, or it doesn't exist, or there are unusual circumstances. So you have to produce it promptly unless you have one of these. And you have to accept the request, so the public agency has to accept the request in any manner or format. Now, there are some towns, I think, that require in writing. There's nothing in statute that requires it in writing, but if the town select board were to pass an ordinance and say any public record request must be in writing, it would be up to the board. If there are staff time costs that are involved, an agency may require a request. That's the one caveat, is if there is going to be staff time involved searching for documents, you can request that and be made in writing. And part of that reason is in order to consult with the requester to clarify the request or get additional information that will help the public agency respond. So let's just say, I mean, we have what we call a frequent flyer who asks for public records on a fairly regular basis, but he doesn't want public records. I want everything on this hard drive in this laptop. That's what he'll ask for. Everything that's on that laptop. And we'll say, okay, there may be a charge for that, because it's going to take us a while to get that figured out. We're going to have to go through it. And we have now, it's clear in the statute that we can actually say to that person, can you tell us what it is you're looking for specifically, so we can try to narrow the request, because it might take us 10 or 12 days to get that to you. But if you tell us sooner, tell us, a little more concise about what it is you're looking for, we may be able to get it to you in 2 days or 3 days. So you have that option to be able to negotiate, if you want to call it, for more clarity on what it is that they're looking for. If the item is in active use, you remember that's one of the other ones, the custodian must make the record available for inspection within 1 calendar week, and you must certify this in writing to the requester and set the date and the hour of the availability. One thing that the changes in the public records law back in 2011 did was to add a lot of in writing. So if you're going to deny, you have to do it in writing. If you're going to say that that you can provide them that document, but it's going to take you a week to get it, you got to do it in writing. If the item is exempt under statute, if there's a specific exemption that you're withholding information for, you must make that determination and notify the requester in writing within 3 business days. So if you're going to deny someone a document or a record because of an exemption, you have to tell them within 3 business days. And in that statement of writing, you must identify the records which are being withheld, the statutory basis for the denial, and supporting facts. For instance, a police report might have social security numbers on it.
Right.
Okay, so you want to redact that. So you want to just be able to tell people, yes, we'll get you the document, but it's going to take us a couple of days to do that, and you have to say this in writing. Sure.
There's a town near here that I was covering for the newspaper that didn't keep their minutes on a website. They don't have an official town website. They did keep them electronically because they would distribute them to me and other folks, other members of the press, public, etc. They would distribute those minutes, but not within that 5 days. And there was a time when I needed those minutes within those 5 days, and they invited me to come to the town hall and examine them. I'm under deadline. I said, can't you just email them to me? Well, we don't have to because we don't maintain them electronically. But they...
Sounds like I do.
That's what I thought too. And so in a case like that, what would be my latitude other than, they kept denying. No, we don't. We keep them in a folder here and we don't have a town website, but they were emailing them, so they're somewhere electronically.
I've never understood the argument why it's so hard to not just attach them and send them by email. Instead of forcing, whether it's you or a member of the public, to drive to the town hall to get a copy and then drive back. We had this up in Washington County as well, in the Montpelier area. And sometimes it's just, you got to talk to the people and just reason with them. Does that make sense? Really, does that make sense? If you have it, if they didn't have it online, okay, fine and dandy. And I guess the question is, do they keep it online, or keep it on file on their computer? Or do they just take it off and just have the paper copy? I can't answer that question.
Okay, but that would be a good follow-up question to ask.
Yeah.
Are you maintaining it somewhere?
Sure, yeah, the law distinguishes, and I'm looking this up right now, between standard paper format and standard electronic format in terms of how they must provide it. So there's nothing in the law that requires them to convert something that they keep on paper to an electronic format for you. They might have something in their own records policies. I've seen language in there both ways. I've seen language that says they will, and under what circumstances they will. I've seen language that says under no circumstances will they. So you could ask to see their records policy. If they have one, that might give you some more clarity.
So if the reason, if you're saying that the record either does not or no longer exist, you must certify that in writing and specifically state that the record does not exist under the name given or by the requester or by any other name known to the custodian. Pretty simple. If the record doesn't exist any longer, you have to submit in writing to certify that says that you don't have it anymore.
Could I ask just a quick question? Is it my understanding, Ian Keel, BCTV, is my understanding a lot of this new certifying in writing, it's essentially to create a public document, right? Like
I wouldn't say it's to create a public document as much as create a paper trail.
Okay. I'm just curious if a refusal to turn over a record, if that refusal is a public document itself.
Well, let me twist it back to you, and let's just say, if you ask me, if I'm the town clerk, and you ask me for something, and I say to you, no, I don't have it anymore, verbally, and you file a lawsuit saying, I think he has it, and you file a lawsuit, then I gotta defend myself. But if I have it in writing, I am defending myself, because I'm certifying that I don't have this document, I'm putting a date on it, and at the same time, you're getting that piece of paper that says, this person certifies that they don't have this document.
The idea of protection, both the public and
It's protection for both people.
Can I ask a question?
Sure.
Carol Hesselback, the Newfane Town Clerk. So I got an email request today for an electronic copy of the grand list. I personally do not have that. I have the paper grand list, which would take me hours to scan in and send to somebody. The listers have an electronic copy of the grand list that I don't have access to. I just forwarded the request to them. They won't see it till Monday because they were gone from the office by the time I did that. Should I have sent this person an email saying, I don't have that, I'm sending it to your request to the people who do?
I don't think it's a bad idea to just send them a quick email and say, I'm not the custodian of that document. I have forwarded it to the listers and they should be in touch with you. And they won't see this until next week or something like that. I think you're just covering yourself that way as well.
Have these laws been the same for the last 25 years?
Well, some of the basis of the law has been the same for a number of years. Actually, that's a good question. Do you know why public records laws came into being and when?
was it Watergate?
All right.
Vermont's public records law came into being around 1976. Watergate was what, 74, I think? But that's exactly right.
And I'll just give you a real, Ian Keel with BCTV. You want to go back to Watergate, Harvard decided to start teaching ethics when they realized most of the people involved in Watergate had graduated from Harvard. A lot of fallout.
So the last one on this section was unusual circumstances. So the deadline, you're supposed to, first, let me just reiterate, if you get a request, you're supposed to give it up promptly if you have it. If you're going to deny it, you have 3 days to deny it. If there are circumstances that where you need to take a little bit longer time, you can, the item is in use or whatever, and you can't get it right away, you can, as long as you set a time within a week. Unusual circumstances might be that you have to search for and collect the records from remote facilities. Not unusual, the town clerk might have a small town clerk's office, and those records that you have might be kept at the Public Works garage, or in your basement at your house, or whatever. It's in a different facility from where you are, so you might have to search for it and collect them. You might, if someone asks for a large volume of records that you have to try to find and assimilate for them, this is where you can also ask to narrow the scope, or if you have to consult with another agency or department. So I'm trying to think of what might be. At the municipal level, you might have something where it's between the town clerk's office and the Public Works folks, highway garage or something. There might be documents that, right-of-way documents or something that are jointly owned or something. In state government, sometimes there are some documents that are held by two different agencies, so one agency must get the permission of the other agency to release them. So you can get up to 10 business days additional for that. Making a determination. Public agencies must produce public records for the inspection and copying unless the record is exempt. The policy says, in the public interest to enable any person to review and criticize government decisions, even though such examination may cause inconvenience or embarrassment. There's that statement again. The burden of proof. Public Records Access Act represents a strong policy favoring access. And out of the Wesco versus Sorrell Supreme Court case in 2004, it said, we construe these exceptions strictly against the custodians of the records and resolve any doubts in favor of disclosure. The burden of proof is on the agency seeking to avoid disclosure. What that basically is saying is that if it's gray area, fall to the side of disclosure. The press loves to hear that. If it's gray area, fall to the side of disclosure. If it's, and the burden of proof is not with the person that requests the documents, the burden of proof lies with the state or government agency to prove their right to deny it. So the person that wants it doesn't have to prove that why they want it or anything like that. So as far as the exemptions go, there are, right now in section 317, there are about 43 or 44, I think, exemptions actually listed. There are a separate listing of them. Also, approximately 200 more are scattered throughout the green books, throughout the statutes. And sometimes it might be just a statement within a sentence that just says that this document, it might be at the very end, it will be kept from disclosure or something like that. And essentially what we tell people is that whether you're a government agency, whether you're a municipality or a state agency, you should understand which are the most usual exemptions that will apply to your particular part of the business, and just be ready to answer that question if it comes up. Because you're not going to know all 240. Although, I will say, the Legislative Council on their website has a list of public records exemptions, and we have a right to know database on our website that also, you can actually do it by keyword, topic, agency, so you can actually look to see what the exemptions are. What if only, and this applies sometimes, actually very often, to a police record. What if only if only part of the record is exempt? So until a couple of, well, 3 or 4 years ago, when they changed the law to make it clear, it was probably, for the most part, understood, but there were occasional cases where if there was one piece of information, if a social security number was in a document, that public agency might withhold that document completely, saying it's got private information that we can't disclose. Today, what it says is you need to redact the exempted information, black it out, and still provide the remainder. And that's why press, when they ask for a police record, sometimes get a page that has nothing but black lines on it. Because the police have determined. Now, the good news is, today, you will also, it doesn't say it here, but you have to provide written information as to why that information was redacted. So you have to identify was it a social security number, medical information, whatever it is, you have to identify it. Do you have to gather, does an public agency have to gather new information or create new documents in order to respond? No. A requester cannot obligate the government to create a record that is not already in existence. So if maybe you have Word documents, but the person says, well, I want it in Excel. Okay, we don't have it in Excel. Now, the government could say, okay, we'll build the Excel file for you, but it's going to cost you. And you have to estimate the cost up front. Must you withhold the document if the exemption applies? It depends. The Public Records Act does not require this, but the outside law might. The safest course is, again, to err on the side of openness and consult your legal counsel. Here's the part about copying and fees. You may charge for copies unless other law applies. What that refers to is if there's another section of the statutes that, like the police records or something where there's a separate charge for something, or if a municipality has their own fee schedule set up. But this still applies. The actual cost of providing a copy, if using your own equipment, established by the Secretary of State's uniform fee schedule or by local legislative body if it so acts. So it's, it still has to come down to what is the actual cost. And that's why you'll see some very small numbers. I think in our fee schedule it says 5 cents for a single page copy, 9 cents for a double page copy. I'm not even sure if we have, does it have anything about?
The fee schedule?
I know we don't have the fee schedule here, but
I do.
for color copies, I think there is a.
Where's the fee schedule?
For color, it's $1 a page. For computer generated, 2 cents per page for pages up to 8.5 by 14. For computer diskettes, 28 cents for a 3.5 inch. I mean, I don't know if anybody uses those anymore. For compact discs, 86 cents for a write once CD with a case, $2.31 for a rewritable CD. If it's an audio tape, 81 cents each. For a videotape, it's $1.69. For a DVD, it's $2 each. So, this needs to be updated, but and it has to be done in conjunction with the governor's team and my team. We're actually going to be looking at that going forward. Something that Jenny said earlier, government has a real tough time with technology. We really do. The statutes do not keep up with technology. They just don't. Think about it. Technology changes about every 6 months. It upgrades or it gets better or something new comes out. I know when I was chair of the government operations, we were dealing with the word email and trying to, say something. This is back in 2003 or 4 when email was just really starting to ramp up. People had it but weren't really using it the way they use it today. And so we were just starting to really ramp up, and legislators wanted to put the word email into the statute, and we ended up deciding that, we don't know 10 years from now what's the next communication going to be. So we put electronic messaging instead. And I would say to you, take a step back 5 or 7 years. How many people knew what Facebook was, Twitter, Instagram, Snapchat? Most people didn't know those things 5 or 7 years ago.
Could I ask you a question on that subject? This is the NKO BCTV. I have videotaped local select boards on behalf of BCTV, and I've seen one town remove a website that pre-existed for certain reasons, and another town have many discussions about maintaining a website. And I'm just curious if on the state level that the state would ever consider creating website infrastructure that municipalities could use. And I asked that question specifically in light of a news report where I believe it was the governor mentioning something like 3 million potential attacks on Vermont data.
I didn't hear that, but I can tell you, we get 5 to 10,000 per day.
Okay. I was just curious if any municipalities have tried to argue to the state that actually maintaining a safe website in the modern era is a financial burden on small towns. And would the state provide an infrastructure that municipalities could use for their own websites? I'm just curious.
Towns themselves really haven't, but VLCT, Vermont League of Cities and Towns, has proposed that idea on some of this stuff to provide some kind of an infrastructure where they could upload stuff. And of course, I think we could throw it right back at VLCT and say, well, you have 246 towns in Vermont and you have 246 members. Why don't you do it? So it's been proposed, it's been thought about, but the state doesn't have the wherewithal either to maintain this. And if you're doing it for 246 towns, you'd probably set it up in a way like we do with our voter registration database, where it's the town clerk that actually deals with the voter registration at their level. And then it just feeds into the statewide one. We as a state I cannot send my team in and say, all right, we're going to take Newfane's voter registration database and we're going to wipe out half of it. That doesn't happen. It's got to come from Newfane. Newfane has to do that. So there would be a lot of rules that would have to be written around that. And, could it happen? I suppose it could in the future. I mean, we've talked about it for legal notices, because it's getting ridiculously expensive in the press to file legal notices.
I guess this is the NKO BCTV. I just raised the question because of observations of local town select boards having quite heavy discussions about website maintenance and that sort of thing.
The town of Montgomery actually pulled their website down right after the 5-day requirement and said, I don't have one full-time person to deal with the website. Well, come on, a full-time person to deal with putting minutes up once every 2 or 3 weeks? I don't think that's necessary, but they did it anyway, and then eventually they brought it back up because then they started to blame the state because people used to pay their water bill and their taxes and whatever online. Now they couldn't because they took the website down. So you got to be careful what you ask for. But no, I think it's something that could happen. Will it happen? I don't know.
Yeah, and I this again, NKO, I have no opinion either way. I brought up the question because of the observation that obviously local towns, the website thing can be vexing or can bring up.
It would sure make it easier for the public to access if they knew where there was one place to go. So.
Who would bring that? Would that be the state legislature?
The state legislature could order it to happen. They'd have to provide funding for it.
Forget that.
So let's see. If there is going to be a fee charged, the agency must provide it upon request prior to actually going out and getting all the documents together and then saying, oh, in order to get these, you now have to pay me $100. You have to give that estimate up front. So this goes back to what we said at the end of the open meeting law. An agency that denies access to non-exempt public records may face litigation and could be charged the requester's court costs. Actually, that law changed before 2011. It used to say the court may portion out the court costs. Now it says the court shall charge the court costs if the person that asked for the documents substantially wins their case. An individual who willfully destroys or discards a public record without authority can face fines as well. We also happen to have the Records Management Unit for the state of Vermont, and as the town clerks will tell you, they have specific disposition orders for almost everything in their office. So they know that if they have this document, they're supposed to keep it for 2 years or 1 year or whatever, and then they can destroy it at that point. And if you destroy something without having the authority to do it, and that would be without authority if you did it prematurely, you could be fined for that. Enforcement, it's always going to the head of the agency. So you can appeal to the head of the agency. The head of the agency has 5 business days. Make the record, either make the records available if he overrules the lower decision to deny. He must make those records available promptly, or he must give an additional notice of denial in writing, including the statutory basis, the statement of reasoning, and the supporting facts, and also the details about your rights to appeal. If the denial is upheld and there is no head of agency, then you can file directly into court. There is a 30-day deadline, generally counted from the date of the denial. And if you see this little piece of paper, the Vermont ACLU and the Professional Journalist Freedom of Information Committee is doing a survey. You can actually go to this website and take that survey, and they will be interested in getting information. They're just looking for people who have filed or had problems or whatever, so that they have a better feel for what's going on. And that's it.
Thank
Two questions that are unrelated.
Okay.
So the first one, we talked about nonprofits.
They're not even cousins.
Not even cousins. No. We talked about nonprofits a little bit, and that sometimes they're involved in open meetings, sometimes they're involved in records. In the situation where a state agency grants funds to a nonprofit for a state purpose,
Doesn't matter.
doesn't matter.
Unless in that grant, the grant would come with a set of rules that they have to follow and requirements. If in that grant it says that they must follow the open meeting law or they must follow public records, then they must. But just because a nonprofit, we have tons of nonprofits who are 100% funded by the state. They don't have to follow open meeting law unless it's required as part of their funding stream or it's required in their charter.
We're in statute, I guess there are, I think the statutes could
That's
actually
true,
say
too.
that too.
Okay.
Designating it as an instrumentality of the state, something like that.
And then the personal part of this is that one Friday I got a call from a reporter and said, I got your name off the White House website.
Oh.
So how?
You felt good about that, didn't you?
Oh, I thought it was great. You know, the other day I actually sent a comment into, I forget what federal agency on a regulation. And they do have the box where you can check, you know, whether you want to submit it. But in the Elections Commission, they never gave that opportunity. The email just appeared on the White House website. So how is that going? I haven't heard anything in the news recently about the Election Commission.
Actually, today, Matt Dunlop, the Secretary of State from Maine, who's one of the Democrats on the commission, was quoted talking to, I think, Huffington Post, saying that he's not even sure they're going to meet again. And then, on the other hand, we don't know. Chris Kobach, who's the co-chair with Mike Pence on this, is one of my colleagues, and he's the Kansas Secretary of State, and he has been trying to do, pull no punches, voter suppression, requiring citizenship, requiring the proof of citizenship, purging people. And the funny thing is, the information that they're asking for, first of all, the first letter came out June 28th and wanted everything. They wanted full names of birth, dates of birth, they wanted your social security number, your driver's license number, anything and everything about you that we might have. We, along with 44 other states, said, no, you can't have that. They then held back because there was now 7 lawsuits filed against the commission. One of the lawsuits had a temporary restraining order. They waited until that temporary restraining order filing was dealt with. Once the restraining order was denied by the court, they then sent out a follow-up letter, and this one asked for what is most likely going to be public information: name, address, year of birth, not full date of birth. They still ask for social security, they still ask for driver's license, but in Vermont, those are off limits. And to date, I have not supplied them with any information, and I have no intentions of it unless a court of law were to tell me that we had to. But I will also say that there are 7 lawsuits filed against this commission, going from its creation, its authority, its membership, all kinds of things that it's been asked about. And myself and the Attorney General, T.J. Donovan, have agreed that we're not going to do anything until the resolution of those lawsuits. It would be irresponsible of us to take an action while those things are still hanging out there. So we're not supplying anything at this point, and I don't anticipate we will. I will tell you, if the information that we could supply them by law was to be supplied, it would give them a lot of false positives. Their goal is to run this through a massive database and purge people from the lists. That's what they want to do. And it's, I think it was the Washington Post, or I'm not sure who it was, one of the press actually went out and went around the country looking at the databases, and just asked, do you have a Mike Pence with this year of birth, And there were 8 of them they found with the same year of birth, 8 Mike Pences. 7 of them had voted. So the question is, does that mean Mike Pence committed voter fraud? But that's what they're asking for. That means there's 8 different Mike Pences out there. Can you imagine John Smith? There's probably thousands of John Smiths with the same year of birth. So long story short, we haven't supplied them anything, and my intention is not to. I only ask one thing: if they do come and send me to jail, would you come bring me cookies and milk?
Can I follow up question?
Sure.
BCTV. Does a federal agency have the authority to purge a voter from purge a name from a state voter roll?
That's one of the questions. That's one of the questions. And I mean, there's a lot of...
But that's never been decided.
No, and actually there was another law that was passed by the legislature here in Vermont back in March of this year. I forget what act it was. Act 5, I think it was. Act number 5. And it was actually designed around the immigration issue, and that the state would not provide any personal information to a federal agency creating a database to look at immigration and whatever. TJ thinks that we're on solid ground by not giving this information up because of that law. So that's another point that you know, we've got going for us as well. Any other questions?
I want to thank you on protecting our voter rights.
Thank you. It's important to me. I take it very, very seriously.
That really frightens me.
Well, the fact that the president continues to this day to say there were 3 to 5 million illegal voters, and they all voted for Hillary. They all voted for Hillary. Oh, that was actually Matt Dunlap had a great comment to the piece about New Hampshire, because Chris Kobach said there were thousands. They were able to prove that there were like 5,000 voters who crossed from Massachusetts to New Hampshire to vote and never got a New Hampshire driver's license. Bill Gardner, the Secretary of State in New Hampshire, said there's no requirement to have a New Hampshire driver's license. And then Matt Dunlap said, that's almost like me saying, do you have money in your wallet? You must have robbed a bank. You know, they're really drawing at straws, and it's really problematic. I'm probably getting too partisan here, but.
I'm wondering what they should be looking at. I mean, the cybersecurity of voting, I know we vote with paper ballots, but they said that people could go into databases, look at who registers or something, you know, is that being enhanced?
Well, from a cybersecurity standpoint, we actually have been fortunate. 4 years ago, we actually embarked, when we started changing all of our IT systems, which, by the way, just that alone enhances them, because the new technology, the new software has built-in systems to protect it. But we also put in a lot of firewalls and protections as well. We also hired a company to do a cyber risk assessment. It was a Vermont company who partnered with a Boston company, and they actually did penetration testing where they actually tried to hack in, and we were successful in stopping them. And I think earlier I said that we were getting 5,000 to 10,000 hits per day of people trying to scan our system, but they don't get anywhere. I will say it's a never-ending battle. Just because we're good today doesn't mean we're good tomorrow. So we have to continually monitor. We're continually looking at what we have to do. We have an MOU with the Department of Homeland Security. Periodically, they do what they call a hygiene scan of our systems to see if they can have access from their point of view. It's just another set of eyes for us. And as Eric knows, tomorrow morning, at 6 a.m., I'll be on a flight to Atlanta, going to a Department of Homeland Security meeting over the weekend to talk about this issue.
With the new gal. With the new gal.
The new gal? Oh, yes. I don't know if she'll be there. That's interesting. She might. She might.
Oh, yeah, she's not been voted.
Right. So that's it.
Thank you.
I hope this has been helpful.
Thank you.